Good evening, everyone. Welcome to our annual World IP Day webinar. So the theme for this year's event is IP and Youth Innovating for a Better Future. So I'll give you a link of the WIPO IP Day webpage also. So, it would be great if you can go through that. So the theme is quite appropriate. Okay, young people have a formidable task of tackling, global issues that require innovation. So climate change, energy security, social issues like quality of life, nutrition, healthcare, national security. So there are so many global challenges that innovation will be at the forefront of solving these global challenges, and especially in India. In the next 20, 30 years, or even 50 years, there'll be a exponential growth in terms of IP related, IPs filed, IP related jobs, and so on. So this year again, we have a distinguished guest with us, Dr. Anindya Sircar. He's with us right now, and he will join us in a minute. So Dr. Anindya Sircar, he is currently the DPIIT IPR Chair at NALSAR University of Law, Hyderabad. He does consulting, he does strategizing, teaching, and training, runs training programs in the field of intellectual property management. Previously, he was the global head of IPR for Biocon Group, AVP head of IP cell at Infosys. Dr. Sircar, he is a registered patent agent. He has a unique distinction of two PhDs, one in science and one in law. And during his long professional involvement in IP, he has seen several acquisition programs, both in and out licensing of IP. And in 2009, he was figured in the Lex Witnesses Hall of Fame as a top 50 prominent player in India's legal sector. And in 2019 and 2020, he was named in the IAM Strategy 300 as a world's leading IPR strategist. So, sir, it's a real pleasure to welcome you on the stream. Great to have you in the World IP Day event.
Thank you, Rahul. It feels great and good to be part of this event. And before we start off, my best wishes of World IP Day to all the participants, to you. In fact, I just always say a few words about IP Day. See, IP Day was started in 2010 after a request from uh, China in 2009, and every year IP Day is associated with a theme, and this year's theme is IP and Youth Innovating for a Better Future, and which is a very, very relevant topic because I find a lot of young people who have joined in, and right now, statistically speaking, there is about 108 billion youth. When I say in this globe, when I say youth, they are below 24 years of age. And 90% of them are from developing countries. That's a huge untapped potential. Who's going to guide us, help us, and to reach some sustainable footing. Okay. So, best wishes of World IP Day.
Great, great. So, sir, I'll ask you a few questions. And of course, the audience is also free to ask, sir, any questions relevant to the topics that we are discussing. And occasionally we will pick questions from the chat. So make sure that the chat, you keep the chat, clean and only, related questions. There is no need to, give your roll number and your name and your institute name in the chat. So if you have any questions, feel free to write on the chat. Meanwhile, we will start the Q&A session with sir. And so, sir, I mean, the natural first question is that, sir, you have had a really long career in IP, a very diverse career. You have been IPR head at Biocon, a pharma giant. You have been the head of IP cell in Infosys, again, IT giant. So tell us a little bit about, what things have changed, what are the difference between these two industries, and in general, how you see IPR progressing in the future.
See, IP from a very high level, from macro perspectives, is very, very similar for most industries. Once you deep dive, It is the domain which decides what kind of activities should be done at what frequency. Now, if you look at the two industries, one is a pharma biotech industry, another is an ICT industry, they are vastly different. So the treatment and generation and maintenance of IP is also different. The main difference is that pharma biotech is very, very R&D oriented, very, very uh, capital intense. It requires a lot of investment, and it requires a much higher gestation period. And then there are far more uh, money at stake. Okay, that means that the risks are higher.
Mm-hmm.
If you are getting into an innovative drug or an innovative biotech molecule, you want to make a new monoclonal antibody, or however, the risks are far far lower for generic molecules.
Mm-hmm.
In the ICT industries, what happens in India is that primarily most of them are service industries. They're not product
Mm-hmm.
companies. Now, in service industry, IP is treated in a totally different manner. What happens is that there are two aspects there. One is, since you are not really making a product, of course, there are a few products which have been made by both Infosys and TCS, etc., which are mainly banking softwares. And when you're in service industry, in most of the cases, the IP belongs to the client. That's the by and large the unwritten rule. But if you look at, Infosys also has several patents, and it is all uh, through their very big R&D team, which is there in multiple locations, mainly focusing on several tools and apps, and of course the the banking application, which is Finacle. I'm sure many of you would have heard of it.
Mm-hmm.
Most of the Indian and foreign banks use this software. So when you're using withdrawing money from the ATM, or
Mm-hmm.
you're doing a transaction on the net, the product which runs behind is Finacle. So those products are protected in a different manner.
Mm-hmm.
And the major difference again is, the technology life. If you look at a pharma and a biotech product, it takes a longer time to develop, a longer time to commercialize, and if you are successful, you have a larger market period. Whereas in ICT, it's just the reverse. The technologies are very, very short lived. I mean, it's just the next technology, the next version just pushes the previous version out of the market.
Mm-hmm.
Unless you have a platform technology, some platform technology which is being used by yourself, or which may be of interest to be used by others. So that way, the treatments are different. The ICT industry relies a lot on copyright and trade secret. Unless there is a tangible product which can be used in multiple locations, products are not very common. Whereas in pharma and biotech, you'll always find that the aim is to patent. The pa- and the patent serves a lot of other purposes as well. It's protection and stopping competition. Plus, it has a lot of economic value also. It does influence the stock market as well.
Mm-hmm. Yeah, yeah. Sir, actually, I get a lot of questions in my sessions, and also you might get a lot of questions. So, a lot of computer science departments of colleges, they are doing innovation, and they are always asking, okay, so we cannot patent our inventions. What should we do then? So they don't fall in this domain of IPR. So, like, what should they do in reality? What should they do? Should they
That's
think
that's
about?
not that's not completely accurate.
Mhm.
See, when you talk about computer-related applications, let me put it that way. Uh, See, as per trips which has been allowed, which has been used, and most of the patent acts are made in with compliance with trips. But the different countries have made different exceptions. So if you look at the Indian Patent Act, Section 3K says that software per se is not patentable. Now that's one thing, per se. But
Mhm.
there are tons of applications, tens of patent applications would get filed in the Indian Patent Office, which are softwares. There are ways and means to get patents. That they tie it up with a hardware, okay, and then there are various tests to be done. The function weight test and the technical hurdle overcoming tests, and what kind of problem it solved. So computer programs, computer related inventions are highly patentable. They get
Mhm.
bucketed into two different kind of claims. One is the method claim, the other is a system claim. So based on what kind of inventions you have, method claims are very easy to be are much easier to be get granted in the Indian Patent Office than system claims. My only suggestion is those computer scientists, those developers who are having a problem with this, they should refer to the government CRI guidelines on IP. It's available on the freely downloadable from the website, and there are various scenarios, various examples, which I guess would help them to move forward.
Mhm. Yeah. So, is there any commercialization stories that you have from either Infosys or either from close competitors in India, let's say, especially in IT industry, where there has been a great success in terms of patents or in terms of other methods of IP
See,
protection?
both the companies you mentioned have a reasonably large uh, patent portfolio. Now, uh, in corporates, patents are business tools. Okay, they are used for commercial advantage. They are not primarily means of improving the CV, which
Hmm.
happens in many other
Yeah.
environments. And patents are expensive, so it takes a lot of uh, care is taken to maintain that portfolio. Now, all of them have commercial and competitive advantages, if not all, most of them. So
Hmm.
they get bucketed into three kind of uh, three kind of what do you say? Three kind of classes.
Hmm.
Okay, the one of those is known as strategic. That means it doesn't help your business today, but it may help you tomorrow.
Hmm.
The second kind is known as defensive, that you need them to continue business. And the third kind are the ones which are deployed.
Hmm.
Now, most of these companies do work and prune these buckets one after the other on a regular basis and try to maintain a clean bucket, so which has a reasonable budget to handle. So success stories as such, it's very difficult to mention on them. It's and not only difficult, it would be improper to for me to correlate a patent with a product and its success. Outside that's a breach.
Yeah. 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 All right. Here I can tell the audience that feel free to ask any questions in the chat. And actually, no need to write the name because it only hides the questions. But sir, one question we have from Arup Barua, and actually, it's a very common question, and I think where the audience is rather from the student undergraduate side. So many people I think are waiting for the right circumstances to basically go into the patent process. So when do you think they are ready? So this question is like, do I need a working prototype to be able to file a patent? So what is the time when people feel ready?
See, you have two questions, okay, in that, Arup. The answer for both of them is no. Okay. I will answer the second question first. Is the idea sufficient? No. The idea has to be converted into a invention. Ideas are not patentable. Ideas need to be converted to an invention. Invention is something which is reproducible. Your idea has not been tested, so it may work, it may not work. Okay, so having an idea just is not at all sufficient. Now, the second question, do I need a working prototype to be able to file a patent? Not always. See, patents are granted on few criterias which the Patent Act defines. Okay, these are very common things like novelty, utility, inventive step, non-obviousness, uh, facts like that. Now, suppose you have a very lousy product, okay, which will never be commercially successful because of the competition on the market. Patent office is not bothered about that. As long as it is novel, inventive, and has utility, they'll give you a patent. They're not bothered. Okay. Suppose you have a new drug which is novel, inventive, and has utility, they'll give you a patent. But having a patent does not allow you to sell the drug against a therapy. That approval has to come from the regulatory bodies. So patent office is not really bothered or doesn't look into these aspects. So you need not have a prototype. As long as your invention is enabled in your disclosures, you can file a patent. And of course, idea is not at all sufficient to move forward.
So, sir, we'll take one more question, which is a bit related. Bhavna Mittal, she has one good idea regarding a testing kit. What's the correct way to collaborate and funding and support? Because, of course, there's a lot of things. It's not just the patent. There's a business side. There's a startup side. So, patent filing should be first, or startup registration should be first. What is the usual way to go about it?
So, see, there is no usual way. It depends how you want to build your business. Okay, if you want to become an entrepreneur, go for a startup registration, file your patent. If you file a patent through a startup, you might get a lot of discount in the statutory fees. That's one model. Okay. Second model is if you want to collaborate with somebody and if you feel that they have some of the strength which you are lacking, could be scale up or marketing, and you can find a proper partner. Okay, then the marriage is successful. Okay, you get the funding and support. Okay. As an individual, without an organization, whether it's startup or something, to get funding on for a natural person is rather difficult in this country. Now, when you say testing kit, the question is, uh, you must also look into that. What is this testing kit all about? Now, there are certain exceptions of patentability in the Indian Patent Act, okay, which makes diagnostic kits as a non-patentable subject matter. Okay. So, if it is a diagnostic kit, that kit itself as a product cannot be patented. But however, the concept can definitely be patented in different ways through a process patent or a system patent. But as such, claiming a diagnostic kit, if it's some other kit, fine, is not patentable under the Indian Patent Act.
Mhm. Yeah. Uh, so one question to continue that earlier discussion on differences of pharma and IT. So, as such, in your career, how you have seen things change in IPR in India? So, do you think that currently there is a lot of action compared to say 5 years ago? And do you think that in the next 5 years it will be a very mainstream topic that will be discussed in everyday academic, conversations?
It should become, there's a lot of change. Lot of change, I would say that in the awareness, in the sensitivity towards it, and the importance of IP has increased at different levels. Now, if you say 10 years, 20 years, well, 10 years, 20 years ago, Rahul Kapoor was not holding a program like this.
True, absolutely. Yeah, there's a demand.
So even 5 years ago, the amount of events and programs which I used to participate were far less. So there is a requirement. And if you really look at today's scenario in our country, you will find that there is too much of such activities going on.
Mhm.
We have had uh, more programs, more workshops in the last 10 years than actually we have had in the last 10 decades.
Mhm. Yeah.
So there has been attempts. Okay, and of course, many of them are just repetitive and talk shows. So that way, there has been a drastic change.
Yeah. So, let's move to this IPR career, as IPR as a career, topic, because uh, we are actually betting on the fact that because IPR is, increasing in terms of the conversation and in terms of filing, and all kinds of different industries are getting more serious about it. So we are hoping that the students who are doing the studies right now, they will have stable jobs in IPR in the future. So, in terms of IPR career, can you shed some light? What is in it for students from different backgrounds?
See, if you really want to be successful in IP, it's a joint venture. The joint venture is between science and technology with legal studies plus management. Because IP is, see, it is science and technology which makes innovation, which makes inventions. It is the legal system which protects them. But the decisions are all commercial. You may have an excellent invention, but it may be commercially not so relevant. So there is a need to have look at the economic value of the invention. So a proper blend, a proper understanding of this will definitely make a person much more, you know, easy to work uh, and enjoy the job. Okay. And again, this is a very common statement which I say in many places. That is, not only do I be take up a job which you like to do. Okay, the world has changed. Okay, don't practice medicine because you became a doctor. Become a doctor because you want to practice medicine. Okay, become a lawyer because you want to practice law. Not that I have to practice law because I become a lawyer. Okay. Sometimes people run after bubble and all those things. So there is a requirement of, because in the next couple of years, or the market dynamics are going to be very, very different with so much of automation coming in. So it will be sometime a little difficult. Now, having said that, if you're looking into a career, there are three places where you can work. Okay, first is a corporate in-house counsel. Okay, you get into a company and work there as a part of the IPR team. Second, you can join a law firm, or if you have entrepreneurship in your mind, you can open your own law firm. Basically, it's law firm job. And third is academia. Okay, you can teach. So
So
if I leave
these are for
academia
law firms. These are for lawyers, for law
for law,
students. Yeah.
yes. No, not only for law students, even for non-lawyers. Today, law firms employ IP specialists, IP analysts, IP researchers who are from STEM background. They need not be lawyers,
Mhm.
because at that level, the science and technology is not is a bit complex, and you need the right domain people to understand and decide on them, make meaningful conclusions, and move forward. So there is a lot of opportunity. See, IP is the hidden career for STEM students.
Mhm. Yeah. Yeah. True. Totally. Totally.
And then you can actually do a lot of analytics work. Okay, you can look for freedom to operate. You can look for valuation, licensing. There, so many of them.
Mhm. So, a lot of webinars, actually, I have conducted a lot of commerce colleges and management colleges come to us also. They say that, I think there are some government guidelines that these institutes, for some accreditation, they need to conduct programs in IPR. So especially for commerce and management students, what would you say? Is there job opportunities, or say, of course you already mentioned analytics. Is there anything else to add to in career?
No, there is. Before there is IP brokerage, there's IP mortgage, there's IP valuation, there is
Hmm.
IP audit, there is informatics, there's IP due diligence. So each of them are career streams,
Hmm.
and they many of the ones which I've just mentioned may be more suitable for a commerce or a management guy than somebody else.
Hmm. Excellent insight, sir. Absolutely. I hope the audience takes this home. A point this take this point home. And yeah, before we continue, I invite questions. If you have any questions, I will highlight them on the chat. Uh, okay, so let's take this question. So Suraj is asking. So how come to know who is a good patent agent and can file accurately? Uh,
Well, this it is. See, everybody has to make a start. A patent agent also has to make a start. Now, if the patent agent is in a respectable or a reputed law firm, you can take to assurance that some checking and valuation of that candidate would have been done before he was recruited. If he is an individual practitioner, then just I would say uh, go to the patent office website which and search and see the patents which he has drafted or prosecuted. You'll get a rough idea about which could comfort you to take a decision.
mhm. Yeah. Yeah. Okay. So, sir, the next theme actually I wanted to ask was about technology commercialization and incubation, basically. So now you are in academic IPR ecosystem also. So, and we have seen also, you also mentioned that IPR has to, there has to be economic benefit. There has to be economic value of the patent that, or the technology that people are working on. But usually college students or PhD students or, academic faculty, they are not very good at the business aspect of IPR.
Mhm.
So, what do you think in this regard? Uh, because that acts as a deterrent for them to file patents. So, what do you think in terms of incubation and commercialization opportunities? What are the options for academicians nowadays?
See, although the numbers are less, okay, there have been several success stories where research institutes and universities, the research carried out there in India, have spun off into companies, and many of them have become successful and grown big. Okay,
Mhm.
this is there in life science, in chemistry, in bioinformatics, and in definitely in ICT. There are several examples, but you can always counter it by saying, look at the number of universities we have, look at the amount of research it is done. It is the numbers are low. The reason for that is not really commercialization reason. The reason for that is the approach. By and large, we have been looking at basic research in academia, okay, and not applied research. Whereas industry looks at only applied research.
Mhm.
All that requires is to move more towards applied research from basic research. Something which is of commercial value. Once you have something which is of commercial value, commercializing it or selling it or licensing it is no big deal.
Mhm.
It should have some a potential of earning money. And it is not just that it complies to a publication in a journal article. It should be patented, okay, which increases the commercial value of the product many. Once that is done, you can always get into whatever mode you want. In fact, there are government bodies like NRDC or TIFAC which helps, and you can today in in this the 75 years of independence celebration, government is encouraging entrepreneurship to a great extent. So you can set up your own shop, function as a startup, or you can also partner with a big company. Okay, all this is possible only if you have something where there is a commercial interest for a lot of other players.
And of course, the natural follow-up question is the funding part. A lot of people, I think taking services of a good law firm is rather expensive, and a lot of institutes this acts as a deterrent. They don't want to spend like lakhs of rupees on patent agent professional fees. So, is there a kind of an equilibrium where where they can get these services at low cost, or at least solve the problem of funding?
See, there is a difference on service. It may law firms claim on quality and professionalism, and that's how the rate change. And see, it is and not on the everybody's service may not be the same. See, it's not a bottle of Coke. Okay, that you buy from the grocery shop, you pay X, and you buy the same Coke from a five-star hotel, you pay 10X. Okay, that's the same product you are getting. Here, the services are different. So there could be differences, and then of course it is each group's business model. Having said that, there is an easier way out. If you go to the Indian Patent Office, there is a list of patent advisors, okay, who are qualified and has got themselves listed there in the Indian Patent Office website. They are supposed to help and assist you at a fixed rate, which is far, far lower than the market rate. This is
Mhm.
controlled by the patent office. So, if initially budget is an issue, I would say you should go to this patent advisors, go to the Indian Patent Office website, click at the list of patent advisors, and look
Mhm.
at the ones probably who suits you, who are in your domain,
Mhm.
and are probably in your city, and get in touch with them. It's not going to be very, very, very expensive at all.
Yeah, absolutely. I mean, if you are serious, okay, folks who are, folks at home who are listening to this, if you are serious, there's really no stopping you. So, honestly,
Let me tell you one more thing. Association like NRDC and TIFAC give you financial assistance, you,
mhm,
both at the time of filing and at the time of granting, if you want to file. And not only for Indian patents, even filing patent overseas, which takes care of a chunk of your expense.
mhm, yeah, yeah. One question is there from Bala Gopi. Actually, this question is also asked a lot. Should we go for publishing or should we go for patenting? Can we not do both? And also, the incentives of the academic scholars is such that, say, if they're a PhD student, they need to publish a couple of articles before their thesis is complete. But there is no such thing that they can have a patent. So usually they are like not
A
incentivized.
patent is also a publication. Okay. Now the question is, get the first thing right. That is, if you have aims of patenting, don't publish.
Mhm.
Okay. Publishing should follow patenting and never the other way. If you publish first, then you are killing the possibilities of your own patent in the future. You are creating
Mhm.
prior art for your own invention. So you can do both. You can first file a patent and then publish. After you have, after you get the, filing receipt, you can go ahead and publish. This is not something which is very uncommon. Uh, Now, the decision to patent is neither science nor law, remember. The first question is you ask yourself, get a check done. Whatever I am calling as my invention, is it patentable? Once you get a yes for that answer, yes, it is patentable, then the subsequent decisions are all commerce, not science and not law. What is the business plan for it? Why I want to patent it? I'm going to patent it so that I have some monopoly in the market because of this patent, which is going to give me some higher, return on investment.
Yeah. Yeah. All right. A lot of folks are saying very valuable session. So yeah, before we move on to the next theme, please feel free to ask questions, and yeah, we will answer them as many as possible. We will answer them with whatever time we have left. Uh, sir, in terms of the fields, so where should the focus be in terms of where to patent? Given that academic institutes are not very good, so how to find that what is useful? So most people are, doing stuff that, like the applied part. Many people don't even know the academy, staying in the academic bubble. They don't know the application areas of what they're doing. So how to, think? What is the mindset shift that is needed?
It's not a mindset shift, that thing is the difference between a basic research and applied research is continuously becoming blurred. Okay, it's all getting mixed up. And it's becoming, it's no longer a circle within a circle, it's becoming a bigger circle. And so, if you know, unless there is a utility, commercial utility, the entire patenting process is I do not encourage that. You might have a
Mhm.
wonderful invention, and you're going to spend money and effort, time, and resource. So why do, unless there's a commercial benefit, you don't do it? Now, if you look at the academic environments, and also to some extent, I would compare that with the initial stages of startup companies. The first thing is that they don't really know whether they have IP or not. You might have done a research project, got some outputs, which may be marvelous. Now, whether that is IP or not,
Mhm.
and whether that can be protected or not, that clarity is missing. Once you get that clarity, there is a sometimes uh, a lot of procrastination. Okay, in what to do, mainly because of financial reasons. Sometimes, and in startups, this procrastination continues because the founders try to do too many things on themselves.
Mhm.
And IP is never a top priority item for them until they go for a B level venture capital funding.
Mhm.
So once you know you have an IP, you have to get a clarity whether you want to protect it, and if so, how. Okay. And then, so you would be disclosing your uh, invention when you patent it. Now, disclosing too little or too much, both are a problem. So you need to have a balance.
Mhm.
Okay, it should be enough to disclose the invention, but at the same time, it should also retain some of your trade secrets and know-hows. Okay, so I normally suggest a multi-layer protection because single layer is not always uh,
Mhm.
sufficient. It could be a mix of, like somebody was asking for a kit. So you can, the device, you can actually patent it for the technical advancement part. You can also go for a design registration for the aesthetic part. Okay, you can also protect it by trademark for the brand equity part. So there are multiple layers. Okay, and all of them could act as a good business tool.
Mhm. Yeah.
Now,
Yeah.
the statement which Rahul made, okay, here the answer is, you must know your market. If you don't know your market, this is all going to be a useless exercise. Now, when I say know your market, it's not today's market alone. You need to know today's market and also the future market, because you need to sustain. Okay. All said and done, whether you have a patent, whether you have IP or not, the most important thing is something else. That is, do not infringe somebody else's IP. It may so happen that you have IP or you don't have IP, you're registered or you're not registered. There are different scenarios. But there is no mercy if you are infringing somebody else's IP. So it's important. It's very, very important to have to check on the freedom to operate part uh, on the on whatever you are trying to commercialize. Are you infringing somebody else's IP? And let me tell you one last thing in this context. It's good to have muscles, but muscles don't matter. The size of your portfolio is not important. It is the quality of patents. You may have two patents which can really change the world rather than having, several thousand patents. So it's always the quality which is far, far more mm, a turning point compared to the quantity.
True. Absolutely. Absolutely. So one of the benefits, folks, for who are watching at home, actually, a good patent can actually make you a millionaire. Really, it's like that way. How it works. So if people are asking, what are the benefits of filing a patent? Don't look at it in isolation. Don't look at it as a academic certificate. So, sir, I'll take this one basic question, which is asked by Sheikh Ashraf, because you were talking about this other kinds of IPR. Uh, so I'm sure a lot of students are there who are not very clear also exactly what entails in IPR. So, what are the new places where people should concentrate, say apart from patents?
See, TRIPS, I think you must have heard of TRIPS, Trade Related Intellectual Property Rights Agreement. TRIPS agreements have defined IP into seven classes. Okay. Patents is one of them. We now understand what is patent, followed by copyright for artistic work, design for aesthetic works. Then you have um, geographical indication, which is like giving a community a right for stuff which is grown or made there, like you have the Darjeeling tea, or rather, I should give a better example, like the Scotch whiskey or the Bordeaux wine, mm, or the champagne. These are geographical indicators. That's another form of GI. You have semiconductor and integrated circuit as another area for protection. Okay, you have the plant breeders right or the plant for asexually reproduced plants. So these are different another protection. Now these are what other different classification being done. I would include one more class here, which is not a classification but very, very important, is contracts. So whenever you are going to be in a process of this, you are going to have contracts. So not only what are these defined forms should give some importance to contract as well.
Mhm. Yeah. All right, great. So I hope it answers also, to the a large part of the audience that there are a lot of stuff to consider, not just patents. So one more question I have actually related to the earlier comment you were making regarding freedom to operate, that you must not infringe on other people's rights. So we have talked about IPR evolution, a lot of webinars such as this are happening. So in the legal context, what do you think about IPR protection in India? Has it improved? Because people a lot of times have this mindset that nothing will happen if they infringe. Let's just do business, and we will settle it in our own way. So how is the
No,
legal framework nowadays?
see, that has changed a lot, and definitely it has improved. Improved in the sense that, uh, uh, see, we become very, very, very worried when you are in a crowded bus and somebody stands on your feet because it pains you. Okay. More than that, you should be worried that you are not standing on somebody else's feet.
Hmm.
That is what I actually mean by infringement.
Hmm.
Okay. Now, how things have changed? Things have changed means that you just look at the sheer number of patents which are getting filed, number of trademarks which are getting registered in the office over the years. They are growing in a steady number. So that means there is an umpteen amount of seriousness in building this ecosystem, and the numbers are on the rise. Now, it is a respect. If you don't respect somebody else's IP, I mean, how do you can expect somebody will respect your IP? Now, having said that, we have all grown up in a situation where our great Sanatan Dharma says, knowledge is for free. So, if knowledge is for free, then why should I pay for to
Hmm.
get some patented stuff? But knowledge is for free, but commercial knowledge is not. And we have also grown in an environment where there is just outside your college there will be a photocopying shop who will be photocopying the entire book at a very subsidized rate.
Hmm.
No, that is blatant copyright violation. And most of the time, students do it without even realizing that they are actually breaking the law.
Yeah, you
So,
make it mainstream, it doesn't feel like it. Yeah.
that those are the things. These are the mindsets which we all have, less or more, and we have grown up with that. That has to change. Okay, that could change only at the right level if you can make the right sensitization.
Hmm.
Now, if you look at what happens if you do and if you are caught infringing a patent, there are courts which are dealing with it. There is a there's a bench in the Delhi High Court set up a few months back which deals only with IP cases. There are two judges there, and they are in the last 2 months itself. They have really made a lot of people happy, and people are appreciating most of the judgments which are coming from them. So that should not be limited to only Delhi High Court. It should, fall further and get into other high courts as well, which I'm sure in the days to come is going to happen.
Hmm. Yeah, definitely. I think that the whole ecosystem has to rise together. You rightly pointed out the recent cases are going to show that sensitization at an earlier level is going to show that, and of course, events such as this and incubation environment that we are seeing, all have to basically come together.
No,
Um,
what kind of respect for IP can we expect if we are photocopying books using pirated software, downloading pirated movies, and
mhm,
that's the first sense of violation. And uh, many of them do not realize that they're doing something wrong because it has become so much of a mainstream activity.
yeah, yeah, true. Uh, so there's one question from Mukesh Sharma, and actually this is also a question I had. So patenting takes a long time, 5 to 7 years, and his concern is that the work is obsolete after that, and it is not suitable for publication also. And also, if you think like bachelor students, they are usually in college for 4 years, so they don't get that time to think about patenting. Or even PhD students, if they are doing PhD for 4 5 years, they are not thinking of it as a viable way, or just the timeline is not matching their own career timeline. So how
If
to
I
think about it?
no, if I talk about the Indian scenario now, Mr. Sharma, it is no longer 5 to 7 years. It's 3 to 4 years. And if you are a startup or a university, okay, you actually get some benefit, which is like of fast tracking your application. It's like the Tatkal scheme which we have. So your applications can get fast tracked, uh, which doesn't happen for big corporates, but for individuals, MSS, MEs, startups, you can always get a fast track. And in this fast track process, mostly in India now, I mean, if not within 1 year, 1.5 years, patents are getting granted in the fast track mode. Okay. Now, you're saying that it's not suitable for publication. You should not wait till the patent is granted or rejected. A decision is taken on the patent. You file your patent and you get a application number and a date and time of filing, a filing receipt. The moment you have that in hand, go for your publication. You
True,
need not wait.
true.
Okay. So that way, once you file a patent, the very next day you can submit your paper for publication.
Yeah, actually, it's a life cycle, and a lot of people think that there are some key events that have to happen before they start doing the next event, but that's usually not the case. If there are prolific inventors who have 10s, 20, 30 patents to their name, they have usually not waited for one after the other. They have a few in parallel, and innovation always keeps going on. Folks in the audience, thank you. I see some comments that it's very useful. We still have some 5 10 minutes to ask some questions from sir. If you have any question, please feel free to write on the chat. Sir, my question I have is just like to wrap it off a bit. So, what are you currently working on, say, in terms of the IPR related projects that you're doing? So, personally, what projects you are undertaking now, and also what you envision, like where you are going to be working on in the future? What should be the area?
This is a two drastically different question. Personally, what I'm doing means, see, I live and breathe IP all the time. So,
Yeah.
um, uh, either I am teaching IP or I am consulting. I have a bunch of clients whom I consult, or
Hmm.
organizing training programs. I have a wonderful team of researchers who carry out research in different contemporary topics so that we get new findings. Our aim is not to patent. Our aim is to look into new research findings and probably uh, come up with new publications. Okay. And that's the way I work. And I'm not saying this is a very ideal way of working. So if you look at how the IP scenario is changing, it's basically a demand situation. Remember, it is. Um, I hope you're doing good. Uh, what I was saying is that see, the entire is a game. The entire IP is a game of two words, which I would say that you should remember it. It's a game between value and risk. So the aim in this game is to maximize your value and minimize your risk. Okay? And the way you are going to bring in the procedures and the policies and other things is really going to make a hell lot of difference. But in a small way or a big way, if you may a big corporate function or you may be an individual inventor, the game remains same. The game is between value and risk.
Mhm.
Remember, you need to maximize your value and minimize your risk. That's all about it.
Yeah, yeah. So yeah, those can be also considered as some words for the young inventors. That end of the day, we are in the value generating business, and as long as that is being satisfied, we can you will succeed in IPR. Uh, all right, Mukesh Sharma. Yeah, thank you. Comment from you. Great. Uh, Kollu Lakesh Yadav. Actually, this question has been answered. How a good patent agent is. So, sir, international patent filing. If you have any words, so this is also a very common question academia asks. So, so, so I understand this is actually kind of a very context-related
Oh,
question.
if you have asked me such a question, I have a counter question. Why do you want to file internationally? Do you think your product or process has reflection there? Today, you want to file a patent in US. Why? Is it going to give you business advantage? Or you are going to license that US patent to somebody in US? What is your business case? If you have a business case, you can file uh, patents wherever, whichever territory you want. Because patents are territorial, you need to file differently. Now, the simple way to file international patent is going to each country's patent office and filing, which is a very, very difficult and cumbersome method. The easier route of doing that would be filing an PCT application, a patent cooperation treaty application, which allows you a single application to be filed in a specific manner, and it is treated as if it is filed in 154 countries as on date. And then it gives you time to think. It gives you some time to think, basically 30 months, to decide out of those 154 countries where you want to proceed, which is excellent because this 30 months you can develop your product, you can develop your partner, you can study your competition, and finalize your market. Which all territories, which all geos you want to proceed.
True. It all depends on the market, and as sir has been saying, it's all about uh, value. So you have to think from a business perspective. I see a great lot of comments thanking us for a wonderful session, sir. It was a really pleasure to have you. And one last question I can say about certificate and feedback form, since someone asked, please wait for an email. You will get an email for the feedback form. And once you fill that form and you have verified your email, you will automatically get the certificate. So yeah, it's very simple. Just wait for the email for 15-20 minutes after the call, after the webinar is over. So, sir, great. Thanks a lot to you. If you have any final words, please, feel free, and yeah,
So
we'll conclude
it's
the
a
session
pleasure
after
to
that.
be here. It's a pleasure. It's always been a pleasure to interact with the younger generation. And if my only point is that I would be happy uh, if whatever I've said is helpful. Okay, so with that I'll say thank you so much, and again best wishes of World IP Day. Have a wonderful evening.
Great. Thank you, everybody. Have a good day. Happy IP day to you, and good luck, and see you in our future events. Bye bye.